The bag lands on the clerk's desk at exactly 11:47 a.m. No announcement, no ceremony, just the muffled thud of black leather hitting laminate wood inside the Santa Barbara Family Law Courthouse, and the sudden, complete stillness that follows it. Court clerk Deja Fontaine does not move. She has processed over 4,000 filings in 11 years behind that desk. She knows the weight of routine paperwork. She knows the weight of motions, appeals, custody amendments. She has held documents that changed children's lives, documents that ended marriages, documents that transferred fortunes. This bag feels different. Her colleague, paralegal Marcus Okafor, steps closer. He glances at the courier, a woman in a charcoal blazer who offers no name, no smile, no small talk, just a sealed manifest and a single instruction. Chain of custody only. Hand to hand. Deja signs. The courier leaves. The door closes. And for a full 3 seconds, neither Deja nor Marcus speaks. Outside the courthouse, 17 journalists stand in the February cold, coffee cups in hand, phones half raised. They have been camped here since dawn, chasing the latest chapter in what the tabloids are calling the most expensive divorce in royal history. They expect another procedural filing, another delay, another round of attorneys billing hours that would make most Americans faint. They have no idea what just walked through that door. Hi viewers, before we go any further, I want to ask you something personal. If you discovered that someone you trusted had been secretly planning to take your children to another country without telling you, what would you do? Drop your answer in the comments right now, because what you are about to hear happened to someone real, and the answer to that question is exactly what broke this entire story open. Back inside, Deja carefully breaks the outer seal on the courier bag. Inside, there is no cover letter, no attorney letterhead, just a bound document, 83 pages thick, stamped in deep navy ink with 4 words across the front cover. The Sandringham Declaration on Sovereign Minor Protections. She reads the title a second time, then a third. Marcus leans over her shoulder. His voice drops to almost nothing. Deja, he pauses. That is not a standard filing code on the bottom of that page. She looks. He is right. The document classification number does not match any California family court category she has ever processed. It belongs to an entirely different legal framework, one that crosses international borders, one that references treaty obligations between sovereign governments, one that carries enforcement mechanisms most American attorneys have never even read. Her hands stay completely steady. Her face does not change. But her eyes find Marcus, and what passes between them in that hallway is not confusion. It is recognition. Something monumental has just entered this building. Something that did not originate in a California law firm. Something that crossed an ocean to land on this desk, in this courthouse, in this quiet coastal city, because someone somewhere decided that quiet was over. Outside, a journalist's phone buzzes. Then another, then 6 at once. Nobody inside the courthouse has leaked a word. But the machinery that produced that document has already begun to move, and machinery that large does not move silently for long. Deja slides the document into the secure processing tray. She picks up her desk phone and dials the presiding judge's direct line. Something she has done exactly twice in 11 years. Judge Renata Holloway answers on the first ring, as if she has been waiting, as if she already knows. Marcus watches Deja's expression shift by a single degree. The kind of shift you only catch if you are standing close enough, if you have known someone long enough. He has worked beside Deja Fontaine for 6 years. He has never seen that particular expression on her face. He leans against the filing cabinet, crosses his arms, and in a voice so low it barely clears the distance between them, he says the words that will echo through this courthouse for the rest of the day. This isn't a filing. He pauses. It's an ending. The document has a name. And the name is Project Mirror. 42 pages. Laminated tabs. Color-coded annexures cross-referencing 17 international legal jurisdictions. To anyone who did not know what they were reading, it looked like a business expansion proposal, the kind of glossy strategic blueprint that gets presented in Dubai conference rooms with floor-to-ceiling glass and waitstaff in white gloves. But forensic analyst Kwame Asante knows exactly what he is reading. He has been awake for 31 hours. His coffee went cold 2 hours ago. He sits inside a secure review room 3 floors above the courthouse floor, and he is not moving until he has mapped every single page. Project Mirror is not a business plan. It is an exit architecture, a meticulously constructed, privately financed, legally insulated escape route, designed to move 2 children across international borders before any American or British court could issue a restraining order. Let that land for a moment. The plan was not reactive. It was not drafted in a moment of desperation. The metadata embedded inside the original digital files, recovered by a forensic IT team operating under direct authorization from the Windsor legal office, shows that the earliest version of Project Mirror was created 14 months ago, revised 9 times, accessed from 3 different devices across 2 continents. Kwame circles a specific line on page 11 with a red marker. It reads, Primary Asset Relocation, Lusail International Education District, Qatar. He flips to Annexure C. There it is. An international school enrollment inquiry. Not submitted once. Submitted 14 times across a single week, which in document forensics does not suggest research. It suggests commitment. The financing structure is routed through an entertainment subsidiary registered under a holding company connected to the Qatari Sovereign Investment Fund. On the surface, it looks like a media partnership. Production deal. The kind of creative arrangement that talent agencies negotiate every quarter. Dig 1 layer deeper, and the structure changes completely. The subsidiary carries a clause, buried on page 31 of the partnership agreement, that grants the primary signatory residency protections under Qatari sovereign law in the event of any custodial or governmental interference with creative operations. Read that clause slowly, because what it means in plain language is this. Once Meghan signed that document and relocated, no American subpoena and no British court order could compel her return. Kwame sets his marker down. He has seen asset protection structures before. He has reviewed offshore accounts, shell companies, dummy trusts. But this is the first time in 14 years of forensic financial work that he has seen a relocation plan that specifically, deliberately, and successfully used children as the commercial anchor for a sovereign protection clause. The children were not incidental to the media empire planned for Doha. They were the product. He stands up, rolls his shoulders, walks to the window and looks down at the journalists still clustered outside. Small figures in the gray February light, with no idea that the document they are waiting to learn about just reclassified this entire situation from a custody dispute into something that sits at the intersection of international law, sovereign finance, and child welfare. His phone buzzes. A message from the lead Windsor legal coordinator, a woman identified in internal correspondence only as Coordinator Simone Adeyemi. For words, "Did you find Annexure G?" Kwame flips to the back of the binder. Annexure G is a single page, stamped, signed, dated 3 months ago. It is a sovereign guarantee of non-extradition, issued under Qatari diplomatic protocol, pre-authorized, and bearing a validation seal that means it was not a draft. It had already been approved. The money does not lie. It never does. Numbers do not have attorneys. They do not issue statements. They do not call press conferences or plant stories in friendly tabloids. They simply sit inside accounts, accumulate timestamps, and wait with infinite patience for the right forensic accountant to come along and read them out loud. Senior forensic accountant Brianna Calloway reads them out loud on a Tuesday morning, inside a sealed evidence review session, and the room gets very quiet very fast. The total figure she places on the table is $2,300,000. That is the amount, across a 22-month period, that was moved through a series of Archwell Foundation subaccounts and directed toward expenditures that bear no relationship to any registered charitable activity of the foundation. Brianna does not editorialize. She does not speculate. She simply presents the documentation, line by line, with the flat precision of someone who has testified in federal court 14 times and learned that facts delivered without emotion hit harder than facts delivered with outrage. First line Hermes, 17 separate acquisitions. Combined total, $340,000. The purchases are time-stamped across a 14-month window. The billing address on each invoice routes through an Archwell subsidiary account registered as Program Operations and Community Engagement. Birkin bags, Brianna confirms without blinking, do not qualify as community engagement under any IRS charitable designation she has encountered. Second line, private aviation. 11 bookings across a 19-month window. For flights routed through Abu Dhabi, 2 through Doha. Combined total, $680,000. The passenger manifests on 3 of those flights list only 1 adult traveler. No foundation staff, no charitable delegation, no beneficiaries of any Archwell program. 1 traveler. Business class converted to private charter. Third line, a Dior account. Established under a personal name but billed through a foundation-linked payment processor. Carrying a running balance of $210,000 across Qatar acquisitions logged in the same fiscal quarters that Archwell publicly reported budget constraints and scaled back 2 education grant disbursements. Brianna pauses here, not for effect, simply because the next item requires a separate exhibit. She opens a second binder. Places it on the table, does not look up. The room is still. The exhibit is a recovered HSBC account statement. Recovered, specifically, from a deleted digital archive that had been professionally wiped using a third-party data erasure service. The erasure was thorough. It would have been invisible to most forensic tools. But the IT team that recovered the Lusail enrollment metadata used a different method. And what they pulled from that deleted archive is not a summary. It is a full transaction record, unredacted, dated, sequenced, bearing a routing number that ties directly to an account that does not appear anywhere in Archwell's publicly filed financial disclosures. Brianna slides the exhibit across the table. This account, she says, voice steady as a courthouse wall, received wire transfers totaling $1.1 million across a 6-month window. The source of those transfers has been identified. The destination of the withdrawals has been identified. She closes the binder. What has not yet been explained by any party is why this account exists at all. In 2024, the document was signed quietly. No cameras, no press release. No public announcement in any British or American newspaper. Just 2 sets of attorneys, 1 conference room, and a 7-page agreement that Meghan's legal team reviewed for less than 40 minutes before signing. Because, as one source with direct knowledge of the negotiation later confirmed, they considered it a formality to preserve titles and nothing more. They were wrong. The Windsor, California Reciprocal Accord of 2024 looks, on its surface, like a title maintenance agreement. A dry, procedural document designed to clarify the ongoing use of royal designations by non-working members of the family living on United States soil. Attorneys on both sides publicly described it as a housekeeping measure. Something to prevent future ambiguity. Something that protected everyone. What Meghan's legal team failed to read carefully And what Windsor legal architects had constructed with extraordinary precision was Article 7, subsection 4. That subsection grants the Crown, under specific triggering conditions, the right to dispatch a designated family representative under diplomatic seal to conduct what the document calls a non-negotiable on-site welfare review of any royal designated minor residing within California jurisdiction. The review cannot be refused, cannot be delayed by American legal process. It carries the operational weight of a diplomatic inspection, which means local law enforcement cannot intervene, and the family's own attorneys cannot be present during initial entry. Legal historian and Windsor Treaty consultant Dr. Adiz Nwosu, speaking on condition of anonymity, described what she read in that subsection with a single word: surgical. The triggering conditions were specific enough that they seemed unlikely to ever apply. But they were written by people who were not guessing. They were written by people who already had the intelligence, who already knew what Project Mirror contained, who had already identified the Lusail School inquiries, the Qatar Sovereign Protection Clause, and the HSBC account that would not surface publicly until forensic accountants opened a second binder in a sealed review room. The accord was not a formality. It was a preloaded mechanism, dormant, precise, waiting for exactly the set of facts that were already being assembled on the other side of the Atlantic. On the morning of February 3, 2026, those triggering conditions were formally certified by a three-person Crown legal panel. Certification took 11 minutes. The dispatch authorization was signed within the hour. At 6:22 a.m. Eastern Time on February 4, 2026, a British Airways flight from Heathrow touched down at Dulles International Airport. Aboard that flight, traveling under a diplomatic travel designation that does not appear on any public passenger manifest, was Lady Louise Windsor. She did not travel with press. She did not travel with a personal assistant. She traveled with two Crown-authorized welfare review specialists, both of whom carry credentials that supersede standard American jurisdictional authority in matters governed by the Accord. She arrived with no announcement. She arrived with a sealed review order. And by 9:15 that same morning, a black SUV was already moving south towards Santa Barbara, carrying a mandate that no attorney in California had the legal power to stop. Prince William has not raised his voice once. Not in the 14 months since the first intelligence report crossed his desk. Not when the Qatar enrollment metadata came back with 14 access timestamps in a single week. Not when the HSBC account was identified. Not when forensic accountants confirmed the Archwell sub-account trail. Not when the sovereign guarantee of non-extradition turned out to be pre-approved and sealed. He has not raised his voice because he has not needed to. The people in that room, Senior Crown Legal Coordinator Simone Adeyemi, Forensic Analyst Kwame Asante, Treaty Architect and Windsor Legal Counsel Reginald Abra, have watched him work for months now. And what they have come to understand about Prince William is this: the quieter he gets, the more complete the preparation. While Meghan's team was working the phones, planting favorable stories in 3 American outlets, coordinating a media strategy that one insider described simply as a scorched earth campaign, William was doing something else entirely. He was reading. He was asking questions. He was sitting in review sessions that lasted 4 hours without a break, circling details that other people had already moved past, and returning to the same question again and again. What does the document actually say? Not what we think it says. What does it actually say? That discipline produced the Windsor, California Reciprocal Accord. That discipline produced the certification timeline. That discipline produced the dispatch order that put Lady Louise Windsor on a plane to Dulles before Meghan's legal team had finished their morning briefing. The contrast between the two approaches is not subtle. On the Sussex side, press statements, coordinated leaks, social media strategy, and a public narrative that required constant management and constant escalation to remain effective. On the Windsor side, sealed rooms, documented evidence, treaty language, and time. Simone Adeyemi, who has spent 23 years working inside Crown legal operations, has a word for what William was doing during those 14 months. She does not use the word often. She reserves it for the kind of preparation that leaves no margin for error, no surface for counterattack, and no version of events in which the outcome is unclear. She calls it architecture, not strategy, not planning. Architecture because strategy can be countered, and planning can be disrupted. But when you build something with the right legal materials in the right sequence with the right treaty frameworks embedded into the foundation, what you build does not fall. It stands. And everything built against it has to come down first. On the morning of February 10, 2026, William sat at a single desk in a Crown legal office and signed a document identified internally as the Tier 1 Non-Engagement Directive. It is not a public document. It will not be filed in any American court. It carries no press release and no public-facing language. What it does is simpler and more complete than any of that. It formally instructs every Windsor-affiliated institution, legal entity, financial partner, and royal household department to cease all forms of direct or indirect engagement with the Sussex brand infrastructure. Effective immediately, without exception, and without any mechanism for appeal. William signed it in blue ink, set the pen down, looked at Reginald Abra across the table, did not say a word. Abra reached for the document, checked the signature, dated it, placed it in the secure courier envelope that had been sitting on the corner of the desk since the start of the meeting, already addressed, already sealed on 3 sides, waiting only for this moment. Outside the window, London was grey and still. Inside that office, the architecture was complete. And 6 time zones away, in a Santa Barbara legal office where phones had been ringing without pause since 9 a.m., Meghan's senior communications director, a woman named Alexis Guerrero, had just received a forwarded email from a Windsor-adjacent media contact who had been a reliable backchannel for 18 months. The email contained 3 words. Step back now. Alexis read it twice, set her phone face down on her desk. And for the first time in 14 months of this campaign, she did not immediately reach for a response. Because somewhere beneath the noise, beneath the press strategy and the coordinated leaks and the scorched earth media calendar, something had shifted. She could not name it yet. She could not see the full shape of it, but she could feel it, the way you feel a door close in a room you cannot see. Not with your ears, with everything else. The folder lands on the conference table at 7:43 a.m. Meghan's lead legal strategist, attorney Dominique Ashford, does not sit down. She stands at the head of the table, both hands flat on the surface, and looks at the 3 people across from her with the expression of someone who has just decided that patience is a luxury they can no longer afford. The folder contains Harry's 2017 mental health records, not summaries, not references, the actual clinical documentation. Session notes, diagnostic evaluations, crisis intervention logs, from the 18-month period following his mother's anniversary memorial when, by his own later admission, he had reached the lowest point of his adult life. Records that were supposed to be sealed. Records that, according to 2 sources with direct knowledge of the Sussex legal operation, had been obtained through a third-party medical records broker working under a confidentiality agreement that would dissolve the moment a court examined it. Dominique calls the strategy targeted context provision. In plain language, it is this: introduce Harry's documented psychological vulnerability into the custody record, not as a direct attack, but as a pattern of evidence suggesting that sole physical custody with Meghan serves the children's stability. Frame his mental health history not as something he survived and addressed, but as an ongoing liability. turn the most human thing about him into a weapon. The three attorneys across the table say nothing for a moment. Then senior litigator Tobias Mensah leans forward. Slowly. Deliberately. The way a man leans forward when he wants everyone in the room to understand that what he is about to say will not be repeated twice. The judge has his complete wellness record from 2019 forward. She already knows the resolution arc. If we present the 2017 material as current risk, she will see the framing before we finish the sentence. Dominique does not blink. We present it as contextual history, not current risk. She will not accept that distinction. We make her accept it. The room holds a long, uncomfortable silence. 48 hours later, the filing is submitted. Meghan's team releases a coordinated background briefing to 2 American media outlets. Carefully worded, carefully sourced, designed to prime public opinion before the evidentiary hearing. The narrative is clean. The language is sympathetic. It describes Harry not as a villain but as a man whose history of emotional instability makes independent sole custody a concern worth examining. By noon, the story is running. By 2 p.m., Harry's legal team, led by Crown Coordinated Counsel Nathaniel Osei, has filed a motion to strike, not a response. The strike motion, accompanied by a sworn declaration from Harry's treating physician, a British Army wellness coordinator, and a child development specialist who has been evaluating both children for 11 months. The strike motion is 40 pages. It is filed with the precision of a document that was prepared before the attack came. Because Nathaniel Osei had anticipated this exact move 6 weeks earlier and had spent those 6 weeks building a counterfiling so complete that it did not just refute the mental health strategy. It exposed the mechanism behind it. On page 22 of the strike motion, there is a footnote. A small, clean, devastating footnote that identifies the third-party medical records broker by name, references the confidentiality agreement by date, and notes that the agreement had been flagged by a medical board ethics panel 3 months prior for a separate records access violation. At 4:47 p.m., a senior aide on Meghan's communications team sends a text to Dominique Ashford from the courthouse steps. The text contains 8 words. The strategy isn't working. The judge isn't blinking. Dominique reads it, sets the phone in her coat pocket, looks straight ahead at the courthouse entrance. And in the gray afternoon light of a February she did not plan for, she understands, for the first time since this campaign began, that they have just handed the other side exactly the ammunition they needed. Not a setback, not a delay, a gift. At 8:01 a.m. on February 12, 2026, Prince William picks up a pen. He does not make a speech. He does not call a press conference. He does not alert a single media contact or authorize a background briefing to any journalist on any continent. He simply opens a manila folder, reviews the single-page authorization document inside it for approximately 90 seconds, and signs his name at the bottom in the same blue ink he used for the non-engagement directive 2 days prior. What he signs is a formal invocation of the 2023 Crown Transparency Statute, a piece of legislation that passed through the British Parliament in a single session with almost no public attention, specifically because its architects intended it to be used quietly, surgically, and without warning. The statute carries one central operational power: the authority to place an immediate, total freeze on any commercial trademark, brand designation, or intellectual property asset that carries a Crown-affiliated title in any jurisdiction under any registration. If the Crown can demonstrate that the asset is being used in a manner that misrepresents royal affiliation, exploits sovereign designation for commercial gain, or operates in conflict with an active legal proceeding involving royal heirs, Crown Counsel Reginald Abera submits the invocation paperwork to the United States Patent and Trademark Office at 8:14 a.m. Simultaneously, Identical filings land in the intellectual property offices of the United Kingdom, Canada, and Australia. By 9:30 a.m., the freeze is confirmed. The Sussex trademark, frozen. The Arch trademark, frozen. The commercial use of the name Lilibet, as registered under 3 separate brand applications across 2 continents, frozen. Read that again. Every commercial application of her own daughter's name, frozen. Not disputed. Not under review. Frozen. Effective immediately. Pending the resolution of the legal proceedings currently active in the Santa Barbara Family Law Courthouse. Forensic brand analyst Camille Oduya, who had been monitoring the Sussex brand portfolio for 11 months at the direction of Windsor Legal Operations, receives the confirmation notice at 9:47 a.m. She pulls up the revenue projection spreadsheets she has been maintaining since the previous April. She looks at the column marked Q1 2026 projected brand income. She looks at the column marked Q1 2026 actual income, post-freeze. The difference is not a reduction. It is not a setback. The second column reads 0. Across every revenue stream tied to every frozen trademark, the projected income for the next quarter is now, legally, completely, and with no mechanism for appeal, 0. Camille closes the spreadsheet. In Santa Barbara, at the same moment, Alexis Guerrero, Meghan's communications director, opens her laptop to begin the morning brand management review. 3 browser tabs fail to load. She refreshes, tries a different browser, picks up her phone and calls the brand licensing coordinator. The call goes to voicemail. She calls the trademark attorney. He answers on the second ring, and what he says to her in the next 45 seconds removes all remaining ambiguity about where this situation now stands. She does not interrupt him. She does not ask him to repeat himself. She simply listens, one hand pressed flat against her desk, until he finishes. When the call ends, she sits completely still for a long moment. Then she opens a new email, addresses it to Dominique Ashford, types 4 words into the subject line, sends it, and closes the laptop. The subject line reads, "We have a problem." 40 minutes later, Dominique Ashford is on a call with 3 trademark attorneys simultaneously, her voice carrying the tight, controlled quality of someone managing a catastrophic development without the luxury of showing it. Because Meghan has just understood something that no press strategy, no coordinated media leak, and no scorched earth campaign can undo. She can no longer use her own children's names to sell anything, to anyone, anywhere. Courtroom 4B is not a large room. 14 rows of public seating. A single press bench on the left side. Pale wood paneling that has absorbed 20 years of Los Angeles County humidity and still looks like it belongs in a government building designed to remind everyone inside it that this place does not care about celebrity. At 10:03 a.m. on February 14, 2026, every seat is full. Judge Renata Holloway enters from the side door at exactly 10:07. She does not look at the gallery. She does not acknowledge the press bench. She sits, opens the case file in front of her, and adjusts her reading glasses with the unhurried movement of a woman who has already decided that today will run on her schedule, not anyone else's. At the respondents' table, Meghan sits in a coral blazer, her posture exact, her expression composed in the particular way that requires conscious effort to maintain. Beside her, Dominique Ashford reviews her notes without looking up. At the petitioner's table, Harry, wearing a dark suit, no tie, his hands folded on the table in front of him, looks straight ahead. Nathaniel Osei sits to his left. Neither of them speaks. The first 90 minutes are procedural. Motions reviewed. Stipulations entered into the record. The kind of courtroom mechanics that the press bench documents without interest because nothing here is new. Then Judge Holloway says, "I will now hear the evidentiary presentation from Petitioner's Counsel regarding Exhibit 44. Nathaniel Osei stands. He does not move to the podium immediately. He picks up a single-bound document from the table, 42 pages, laminated tabs, color-coded annexures, and carries it to the evidence submission bench with the careful deliberateness of someone transporting something irreplaceable. He places it on the bench. He turns to face the courtroom. Your Honor, Exhibit 44 is a document recovered through forensic digital analysis, identified by its internal title as Project Mirror. It is a 42-page relocation manual, prepared across a 14-month period, revised 9 times, accessed from 3 separate devices across 2 continents, and containing, at Annexure G, a pre-approved sovereign guarantee of non-extradition issued under Qatari diplomatic protocol. The press bench goes completely still. The forensic metadata embedded in the original digital files establishes the document's creation date, its revision history, and its access pattern. It also establishes that the primary device used to access enrollment documentation for the Lusail International Education District in Qatar, 14 separate access events in a single week, is registered to the respondent. Harry's hands, still folded on the table, do not move, but his eyes do. He turns. Slowly, the way a person turns when they are processing something they cannot immediately organize into language, and he looks at the bound document now sitting on the evidence bench. The document he is seeing for the first time. The 42-page architecture of a plan that would have put his children on a plane to a country whose legal framework would have made it nearly impossible for him to follow. His jaw tightens. 1 degree. A movement so small that only the people closest to him catch it. Kwame Asante, seated in the 3rd row of the gallery, watches Harry's face and later tells a colleague that what he saw in that moment was not anger, was not devastation, was not the dramatic collapse that a lesser storyteller would reach for. What he saw was a man doing the hardest possible version of staying composed. Because the alternative was giving the room something they would never stop talking about, and Harry has learned, at enormous cost, exactly what rooms like this do with moments like that. Judge Holloway removes her glasses, sets them on the bench, leans forward exactly 1 inch. The room does not breathe. Counsel, she says, her voice carrying the particular weight of a woman who has presided over this courtroom for 16 years and has never once needed to raise it. I want the respondent's full explanation of Annexure G on the record before this session closes. Dominique Ashford rises. But Judge Holloway is not looking at Dominique Ashford. She is looking directly at Meghan. The silence lasts 4 seconds. In a courtroom, 4 seconds of silence is not nothing. It is a geological event. It reshapes the landscape of everything that came before it and everything that comes after. Dominique Ashford speaks for 11 minutes. She uses careful language, measured language, the language of an attorney who understands that the ground beneath her argument has shifted and is attempting, with everything she has left, to find stable footing. She describes Annexure G as a preliminary exploratory instrument. She describes the Lusail access pattern as research consistent with any parent examining international educational options. She describes Project Mirror itself as an internal planning document that was never activated. Judge Renata Holloway listens to all 11 minutes without interrupting. When Dominique sits down, the judge picks up her pen, does not write anything, simply holds it, and then she looks up, not at the attorneys, not at the gallery, not at the press bench, directly at Meghan. The look does not last long, but it contains everything. In 14 years on this bench, Judge Holloway says, her voice even and absolute, I have not encountered a custodial strategy that so completely attempts to hold 2 contradictory positions at the same time. She pauses. You cannot weaponize motherhood and reject responsibility in the same breath. The press bench erupts in the sound of 14 keyboards activating simultaneously. In the gallery, Kwame Asante presses his pen into his notepad and does not write anything. He does not need to. That sentence has already written itself into the permanent record of this proceeding, and it will not be revised or appealed or walked back by any filing, any statement, or any coordinated media response. It is in the record. It is final. It is, in the language of the courtroom, irrevocable. The rulings come in sequence, each one delivered in the same level tone, each one landing in the room like a separate weight dropped from the same height. The Archwell Foundation is ordered into immediate administrative dissolution pending a full financial audit. The $2.3 million sub-account expenditure is flagged for referral to the California Attorney General's Charitable Oversight Division. A reimbursement order of $1,300,000 is entered against the respondent personally, covering legal costs, forensic analysis fees, and diplomatic coordination expenses incurred by the petitioner's team as a direct result of the Project Mirror discovery. Physical custody of both children is transferred, effective within 72 hours, to a joint guardianship structure overseen by Princess Catherine and Duchess Sophie, with Harry retaining full visitation rights on a documented schedule. The Windsor, California Reciprocal Accord remains active. The trademark freeze remains in effect. At 1:17 p.m., Judge Holloway closes the file. At 1:22 p.m., Meghan walks out of the courthouse into a February afternoon that offers no ceremony, no crowd management, no prepared press position. Her communications team is not on the steps. Her usual security detail has been reduced to a single contracted driver. The car waiting at the curb is not the black Escalade. It is a mid-range sedan. Gray. Unremarkable. She gets in. Alone. The door closes. The car moves into traffic and disappears. On the courthouse steps, a journalist from a British outlet turns to her colleague and says something that does not make the broadcast but gets repeated in every newsroom in London by evening. That's the first time I've covered her in 4 years and there was no one waiting. Inside the courtroom, Harry remains seated for several minutes after the gallery has cleared. Nathaniel Osei sits beside him, says nothing, and gives him the time. Eventually Harry stands, buttons his jacket, picks up the single item he brought to the table, not a legal folder, not a phone. A photograph, small, unframed. 2 children in a garden. He puts it in his inside pocket, over his heart, and walks out. The statement arrives at the Windsor legal office at 6:14 a.m. on February 15, 2026. It is handwritten. 3 pages. No letterhead. No royal designation. No reference to titles, brands, foundations, or public positions of any kind. It is signed at the bottom of the 3rd page with 4 names, not a title, not a designation, not a brand. Henry Charles Albert David. That is all. Legal coordinator Simone Adeyemi reads it twice before passing it to Reginald Abra. He reads it once, sets it down, looks at the window. Outside, Windsor is just beginning to catch the first pale light of a February morning, the kind of light that arrives without drama, without announcement, that simply shows up and makes everything visible. The statement does not argue. It does not perform. It does not position or spin or attempt to recover what has been lost in the preceding 72 hours. It simply states, in plain and unadorned language, what Harry intends to do with the rest of the time he has as a father. Where he intends to live. How he intends to show up for his children. What he is willing to surrender, every title, every commercial designation, every brand extension, in exchange for one thing. Access. Consistency. Presence. Nothing in the document references Meghan by name. Nothing in it references the legal proceedings, the financial findings, the Project Mirror revelation, or the courtroom exchange that has already been quoted in 17 countries. Contains no score settling, no vindication language, no carefully worded passive aggression dressed up as dignity. It is simply a father writing down what he knows to be true about himself, for the first time without anyone telling him what that truth should look like. Princess Catherine receives a copy at 7:30 a.m. She reads it in a private sitting room at Kensington Palace, alone, and does not share her response with anyone present, because no one is present. Duchess Sophie receives hers at 7:45 a.m., and a source with knowledge of that morning describes her reaction as very long silence, and then a single nod. The guardianship transition begins at 10 a.m., on schedule without incident. Both children are collected by a Crown-coordinated family liaison team in the presence of Harry and both royal guardians. No press, no cameras, no documentation released to the public. A Windsor communications aide later confirms the transition in a 4-sentence statement that provides no photographs and invites no follow-up questions. For sentences, that is the entire public-facing footprint of a moment that 14 months of legal architecture, forensic analysis, treaty invocation, and international coordination was built to produce. Kwame Asante, standing outside the Windsor legal office at noon, looks up at the upper windows of the building, where, on a different floor in a different room, the sealed documentation of the entire Project Mirror operation is being filed, catalogued, and secured for permanent legal record.